This is Legal Live with Eddie and Chuck Farah. They're talking the latest legal news and answering your questions. To call Legal Live and ask Eddie and Chuck a question, grab your phone and dial 855-765-1045. That's 855-765-1045.
You heard the number. Pick up the phone. Give them a call. 855-765-1045 puts you in touch with our legal gurus, Eddie Farah, Chuck Farah from the law firm of Farah & Farah, your hosts for Legal Live, standing by to take your questions. Your calls are the best part of the show, so reach out and join us right now and make some magic happen. Who knows what we'll learn? But other people are probably wondering the same things you are. So again, give us a call, 855-765-1045, and we'll put you in touch with the sultans of the courtroom, the maestros of jurisprudence, the grand high poobahs of personal injury, Chuck and Eddie Farah. Fellas, how you doing today?
Keep going, Scott. How much are they paying you to say that?
Not enough.
Yeah, that's true. to make those type of statements, you need a lot of money. But we got a lot to talk about today, and I really want to kind of pick up on some of the stuff we talked about last week, and get people's opinions on it. With the trial going up in Brunswick, Georgia, and all the George Floyd stuff that's still going on and everything, and how that, and there was a decision this week that came down from the U.S. Supreme Court that involved two different cases, kind of similar, where they were trying, the basis of these lawsuits were suing the police officers for using excessive force. And there's a principle that we talked about last week of qualified immunity that makes it difficult, very difficult, to sue a police officer for a civil rights violation, and how these Supreme Court decisions are kind of varied, maybe are inconsistent, a lot of them. The facts seem very similar, and the court is coming up with different results, which is not good because people love consistency. We all like consistency. We all like to know where we stand.
It makes it really hard to set a precedent if they keep changing the precedents.
Yes, if the rules change, then it's nobody knows. The police officers don't know. Nobody knows. So we'll talk about that for a second. But I did. I appreciate you're getting me excited, Scott. That give me shelter intro. The Stones are on tour right now. This No Filter thing.
Oh, and their final show is going to be down at the Hollywood Seminole Casino.
Yeah. You're going to be missing me in a couple of weeks because I'll be in Upland at the Mercedes-Benz Dome checking it out, and I'll report back the following week. But anyway,
we should do the show from remote there.
Yeah, I'll do. Yeah, I'll be there. I'll be there in pit 1, so be looking for me. Yeah, you're welcome to come.
You're missing the operative word on this.
I know, man.
And it sounds like you're missing it on purpose.
And listen, no, man, we'd love to have you there. I've seen it probably 30 times. First time I saw him, 1975 here in Jacksonville. And I've got a T-shirt from that show at the old Gator Bowl. But we can talk about that later. Let's get into
first time I saw him was I caught a Greyhound bus from North Georgia down to Orlando on that Still Life tour. Mm-hmm. Unbelievable. That was a long ride, man.
Yeah,
especially on the way back.
Worth it. It was worth it. But anyway, let's get into some legal stuff that we think you need to know, or maybe are just of interest to you. And again, your phone calls, your opinions. Look, guys, don't feel you got to hold back. We express opinions. Sometimes we do, sometimes we don't. If you don't agree, feel free to call in and give your side of it. You're not going to upset us. We want the other side to be heard. We want all sides heard.
No, you might upset us, but we'll get over it.
And if we do get upset, don't worry about it.
The only way you get the whole picture is to get other perspectives on it.
We want it. Don't feel like, we want the other side.
Yeah,
if you want to lash out, you need to lash out. Lash out. We can handle it. We've been through a lot, and there's nothing. I don't know. Probably handle anything you throw at us, but test us out.
Let's try this before we even get the ball rolling today. We've got our first caller on the queue. We got Bill from Mandarin, and he's got some questions regarding the stand your ground rules.
Right.
Hey, Bill, you're on Legal Live.
Yeah. Hey, guys. Hey, just curious. If on the stand your ground rule, right? Whether it's, I take it as when you should and when you shouldn't. You know, when you should walk away and when you should. You're like, dude, you're in my space, and I'm concerned you're going to hurt me, type thing. If when can you actually retaliate if someone's real aggressive to you, and they're coming at you in an aggressive way? Are you supposed to turn and run, or is that stand your ground rule mean that you can defend yourself? Or let's say someone did something to a family member or a friend or just a stranger right in front of you. Are you allowed to help protect that person?
Well,
with that stand your ground rule?
Well, I'm not a criminal law lawyer, okay?
Yeah.
But I know that if you're in fear of imminent harm, imminent bodily harm, you have a right to defend yourself. There's no the stand your ground. In my understanding, the stand your ground took away the requirement of you to retreat. Okay, that's what it stand your ground. You don't have to leave. You can stand your ground and protect yourself. Now we're civil law lawyers, so we handle the lawsuits. I remember a case that even though the person was allowed to go free on a stand your ground argument, it did not give him immunity from a civil lawsuit for money damages. So that's what you have to look at. I mean, just because you say, "Oh, I'm not guilty because of stand your ground," I can still be sued for money damages for the injuries that I may have caused.
Yeah. So the language is when provides that people may use deadly force when they reasonably believe they need it to defend themselves against deadly force or major bodily injury. So it's really from the perspective of the person invoking the stand your ground rule. Did that person? So it's like a different, I mean, it's a great defense. I mean,
yeah, I mean, it's a controversial defense right now. I mean, the question is, listen, it's a fact-specific situation. There was a case I think we talked about a few years ago where a guy put his hand through, tried to grab somebody in the car, like he was outside, and the guy took a gun out and shot him. And the court said that will stand your ground. I mean, I don't know. I mean, yeah. I mean, it's fact-specific. I mean, a jury would ultimately decide if the stand your ground applied to you. You go in front of a jury, and if you pled the stand your ground defense, you're probably going to hear some of that going on in the Aubrey trial up in Brunswick. I've been trying to keep up with it a little bit, but I think that's where the defense is coming from, a sort of stand your ground argument.
Right. Yeah, I don't know that you can step into the shoes of and be the aggressor in place of someone else who feels that harm, towards them, that potential harm. I'm not sure about that.
Did you guys see that? Did you guys see that thing up in Pennsylvania where that last week where the woman was being raped right on the transit train, and all the people were around there and didn't do anything?
Nobody did anything.
Somebody should have jumped in. The police said that somebody should have stopped them, and any sane person should have stopped them. But so right there, you're kind of on the what do you do on a legal standpoint? What if you grab that guy and you threw him off and you killed him by he banged his head, and you just getting involved there and naturally doing the right thing, but now you're in a bad way.
Yeah, you're facing a criminal. Yeah, I don't know. I have to look. That's a good question, and I'd like to talk to a criminal.
Else, you'd be like looking at a potential manslaughter charge or something like that in the situation.
Yeah, but
that's a very good question.
Would they really? It's all up to the prosecutor to prosecute. Would a prosecutor, if you went too far, I mean, I don't know, maybe he said I wasn't trying to rape her, I don't know, attempted rape, or, I mean, attempted rape or whatever doesn't give you the death penalty. And you kill the guy. I mean, did you exceed your? I mean, yeah, that's a good point.
Right.
I mean, the prosecutor could come after you. You're right.
I mean, that's probably why all those however many people on that train didn't do anything. Because in the back of the head, they're thinking, I could be in jail.
Yeah, something goes wrong.
And that poor girl got. I mean, it's terrible.
Yeah.
Hey, I actually had a judge tell a friend of mine, because I was in court with him, when somebody came at him aggressively, and the guy got within a couple feet of him, and he was coming at him aggressively, and he pushed him back, and there was a witness that showed him push the guy back to get him back out of his space. He didn't even punch him. He just pushed him back. And then when it went to court for to file a restraining order on the guy, the judge said, "Could you have walked away?" And the guy was an honest guy, and he said, "Yeah, I guess I could have walked away because And the judge said, "Okay, you got a restraining order against you."
Yeah. Well, did he have
crazy.
Did he have a restraining order at the time the incident occurred?
No.
Are you sure about? Because that's what Judge Will, I think, was getting at. Why didn't? Because you have a restraining order against you. Why didn't you just walk away? But he didn't have it at the time.
No, he didn't. He had no restraining orders on him. And the guy had video of him on a sidewalk where it was a street behind him, but the guy was an honest guy, and he just said, "Yeah, I guess I could have walked away."
Mm-hmm.
Well, in that case, the guy incriminated himself, and basically he said, I could have chosen another action. I chose to do this, and it shows he put some thought into it, which makes it an unintentional action. And I'm sure he may have been trying to avoid a bigger problem, but he still, acted willfully.
But it's easy to say I could have walked away, but when you're in the heat of the moment, everybody says, "Yeah, I'm thinking about it. If I had time to think about it," but at the heat of this.
By the same token, if he walked away, who's to say he's not going to get hit in the back of the head?
Yeah, or get attacked that way. Exactly. Get
hey, or if he didn't do anything, let the guy keep coming at him. The guy could have punched him, knifed him, killed him.
Sucker punched him.
So I mean, it's just so hard to find the reasoning behind that one.
Yeah, I know. I mean, I don't know. I mean, those restraining orders are civil. I mean, they got the force of law. I mean, they're enforceable. But I don't know. I mean, that's an area of the law that we really don't practice. But it's a great question, and it's an interesting argument.
Yeah.
But I know it's
all right, guys. Well, hey,
thanks a lot.
Enjoy your show. I'll keep listening.
Yeah, man.
Thanks for calling.
Hey, Bill, thanks for contributing to the conversation there, man, and directing us where to go.
Mm-hmm.
We've got Tim in Orange Park. He's got a question for us now. Also, Tim with a question about the Do Not Call list. Hey, Tim, you're on Legal Live.
Hey there. How are you doing today?
Hey, Tim.
Hey there. I've just got a question. Many times telemarketers will hire a marketing company to generate business, and from my understanding, I had was looking at the U.S. versus Dish case, and are the companies that hired the marketing company just as liable if there was a DNC violation?
Probably.
If they're working for their agent.
Yeah, if they're working for them, yeah.
Okay, because I just wanted to make sure on that, because I'm trying to stay pretty active with my right as a consumer to for any violation where I can actually send a request to them. But I've had some say, well, that was a marketing company and we're not liable, and I disagree with that.
Have you looked at the statute, the federal statute that governs it?
I have. It's very vague. It just says anybody who makes the phone call or text or anything. But it was when I looked at the U.S. versus Dish, which was based upon that similar situation where Dish hired a marketing company to generate all of their business, and turned out that marketing company did not honor the DNC laws, and so they actually held Dish just as liable as the companies, from my understanding. But I want to make sure I was reading that right, and just wanted to ask about that.
But if you read the law, that probably talks about who's responsible. It's the person who does it, their contractor, their subsidiary, their agent. You probably have all that covered, because if the statute didn't include that, then somebody like Dish could escape liability by saying, "Okay, I'm going to hire this marketing company to do it. Y'all go do it, and I'm insulated." So the law should really cover everybody involved. I mean, that way you could escape liability. I'm not going to do it. I'm going to hire these guys to do it. And these guys who are going to do it, if they get sued, who cares? They don't have any money anyway. I'm the big kahuna. I got all the money, and they can't come after me. So if just by what I know, the statute probably covers, the contractors, the subcontractors, the independent contractors, anybody you hire to do it.
Yeah,
gotcha.
It has to,
because if people could get around as a loophole, they could get around it.
Right.
Yeah.
Right. Excellent. That helps me out. Thank you so much.
Yeah. Thanks. I mean, it's like Tim brings up a good point. There are certain duties under the law that are non-delegable duties. You can't delegate them out. Like, for instance, if I'm Walmart and I hire an independent security company to come and keep watch over my store, and the security company doesn't do their job and they get sued. Well, Walmart, even though they're an independent contractor, Walmart's still responsible for what happens or for the wrongful conduct of the security company. That's considered a non-delegable duty. You can't delegate it out to escape liability.
Well, guys, we're going to take our first break of the show. I see Steve is still on the line, and we're going to come back to your question in just a couple of minutes. Steve, stand by for us. We'll be back with more of your legal questions here on Legal Live on 104.5 WOKV, Jacksonville's News and Talk. Jacksonville, we're back. Legal Live with Chuck and Eddie Farah. If you want to jump in the conversation, 855-765-1045, the number to call. And we've got Steve on the line. He's got a question regarding a settlement on a house or a construction question. Hey, Steve, you're on Legal Live.
Good morning.
Hey, Steve.
Are you there?
Oh, yeah, we're here. Go ahead.
Good, thank you. Eddie, several months ago, you took a caller that had a very similar situation like mine. The house was almost new. The roof was falling off of it. And I told you I knew exactly who the roofer was and who the builder was.
Mm-hmm.
Well, guess what? We settled my case here about 3 weeks ago.
Mm-hmm.
And bear in mind, the insurance company flat refused to pay a penny. Well, the insurance company settled out for $30,000. Of course, the lawyer gets his cut off of it, and then we get some left to do our roof with. So I asked my attorney how he was able to settle it, and he said that the insurance company agreed to go back on the builder and the roofer for insurance fraud because they agreed to insure a house based on all the reports and all the signatures that the house was legitimate. Mm-hmm. How is it going to look on the builder whenever people see that they have an insurance fraud claim against them? Is that going to be public knowledge?
If the lawsuit is filed, you can look it up. I mean, there won't be a database. You can go to, are you in Duval County?
Yes, sir.
Yeah, you can go check their name to see if they're a defendant in a lawsuit. But I don't think it's posted anywhere. But what happened in this case is that the insurance company paid $30,000, and you assigned over to them all of your rights in that case. So they can go back, and it's called subrogation. I mean, people do it all the time. I mean, car insurance companies do it. Everybody does it. A lot of these people do it. And so they're going back to get all their money back.
Yeah.
What they're doing.
The problem is the language. There'll be a release signed, and it won't allow, there'll be language in the release that says they do not admit to any liability. Yeah. Because it's a settlement.
Mm-hmm. Exactly.
Yeah, so even if the roofing company pays back some money to the insurance company, there will not be an admission of guilt. The only way there'll be admission of fault is if they took them to a trial and a jury came back and said, yeah, y'all were fraudulent. Otherwise, like Chuck said, if they pay any money back to the insurance company for your claim, there will not be admission of guilt.
Well, refresh your memory just a little bit. We tried to settle this being Mr. Nice Guy.
Right.
Because we got the insurance company out here. They refused it. We got 3 roofers, not at the same time, but, one about every other week, something like that. And I got statements from them, and I got a letter from the shingle manufacturer that it was all shoddy workmanship. And I called the builder, and I said, listen, I'll even pay the upgrade difference between shingles and architectural. All I want is my roof. I don't want a lawyer involved. Don't want anybody going to court. All I want to do is put a roof on my house because that's what I paid for. He refused to do it. And now then he had to settle it, or he's going to have to settle it with the insurance company.
Yeah, but he didn't pay you any money. So he's figuring, and he may be able, let me just tell you, did he have an insurance company?
Me or him?
No, the roofer.
I don't even know if the roofer can be found.
Yeah. Well, they're going to have to try to go find him if he's
They're leaving that option open to them if they can recover some money.
Yeah, and the thing about it is they may sue him or try to sue him or whatever, and he may come back and say, well, listen, here, I got $10,000, take it or leave it. And and they're happy to get at least $10,000 of their money back. I mean, it's like anything else. They're going to assess the situation and see if it's worth filing suit against that guy,
Don't you love lawyers now? Lawyers are great.
I don't have any problem with attorneys that are keeping their clients' interest at heart. But, we tried to be nice about this.
Yeah.
And I've got 4 statements, signed statements. And I took it to the builder, and I said, hey, listen, I said, all I'm asking you to do is just put a roof on my house. I'll either pay the difference between an upgrade to an architectural shingle. Builder refused to do it. I said, okay, good luck. I'll see you in court.
Yeah.
And I found an attorney to handle it.
Yeah. Very good. I'm glad
it worked out for you. That's good news. We love
Oh,
hearing
yeah.
this.
Now, I told the lawyer, I said, whenever I'm done with the roof, I'm going to go after the builder. He said, why? I said, because every time my wife saw a cloud in the sky, I had to listen to her bellyache about that roof, and it raining.
Mm-hmm. Yeah. I tell you, you don't have a roof, you got nothing. We know that.
Exactly.
You got nothing
exactly.
without a roof, man. So,
well, thank you for your radio show. I listen to you every Saturday when I can. Take care.
Thanks
Steve,
for calling in.
Hey, Steve, we appreciate the call.
You know what? It's good to hear a good result. A lot of times people call in and they just can't get any kind of, any closure or good result.
Here's the thing: the law works
that got
for you.
A good result. The law, it does work.
It does work for you, but you got to get the right application of it.
Yeah.
Because it's there to protect everybody, and that includes the people who are sometimes working and not necessarily your interests. Hey, 855-765-1045 is the number to call. We've got lines open, and we'll be taking some more calls when we get back after this quick break on 104.5 WOKV, Jacksonville's News and Talk. Jacksonville, we are back on Legal Live, 855-765-1045, and we are joined by a frequent friend and visitor here on Legal Live, Brian Flaherty, checking in with us. Brian, welcome back to the show. How are you today, bud?
Hold on, I'm not
doing
ready.
Great.
I'm not ready for this. I'm not ready for this.
I don't know what to say, Chuck. I don't know what to tell you.
All right, just give me a second just to kind of get some composure.
Let me get some composure here. Go ahead, Brian.
Is it too much information going on here? Is it like too much machismo in the room now?
They're killing me.
All right. So can I guess we're talking about stand your ground?
Yeah, you're actually talking about two different subjects, and stand your ground gets back to the subject I'll address first. Both of these were standards that were adopted from Supreme Court cases in regard to qualified immunity, and then the stand your ground, which is the use of deadly force. And it all goes back to what I've talked about before, which is the use of deadly force goes back to a Supreme Court case, Tennessee versus Garner in the late 80s, in which the Supreme Court gave, and I call them the 6 magic words. Police officers, law enforcement across the country, doesn't matter, federal, state, or otherwise, all of them are guided by this 6 magic words, as I put it. The only time you can use deadly force, and that's not just the firearm, but it's other things as well, but deadly force is when there's a reasonable belief, and that's a reasonable man's belief. And the 6 magic words are as follows: a reasonable belief of imminent death or great bodily harm. So for police officers, they have to have those 6 words that would apply to their decision at that moment in time to use deadly force. And that can be an expandable baton in the upper portion of the body. That can be anything else, including a gun. And it means literally just what it is, which is a reasonable belief of imminent death or great bodily harm. And we'll get back to the example they gave of the woman who was being raped on the subway train in a moment. But for stand your ground, Florida modified it, and so that there's not the 6 words that applies to the police officer, but 5. They took out the word imminent. So there has to be a reasonable belief, and then you've got the 5 remaining words of death or great bodily harm. And that could apply to you or somebody right at the moment in time, meaning if you do that, if you use deadly force, those 5 words better apply to the situation. Now, coming back to the example in Philadelphia, that is an example in my mind, based on what I've read in the media, in which both a civilian or a police officer could have used deadly force on that rapist in the midst of that crime and been totally justified in the use of that deadly force in defense of that woman. That would have been an appropriate use of it at that moment in time.
Yeah, that would have been the defense is that it was justified. Is that what you're saying?
Yeah. Absolutely, because
is it only, so it's not just you. If somebody else is an imminent threat,
Yes. Well,
Okay.
a reasonable belief, and it's not imminent for the
right.
That's
reasonable,
the Florida
it's imminent
exception
for a law
for it.
enforcement officer, trained law enforcement officer.
Right.
But for stand your ground in Florida, and again, this happened in the state of Pennsylvania, but in Florida, it means that the 5 words of the 6 apply. The word imminent's out. Means a reasonable belief of death or great bodily harm. And there were some things about, I felt threatened, and they were saying mean words to me, and I don't know what their intentions were. None of that, based on what I was listening to, would apply to using deadly force. You are going to be charged accordingly if you go ahead and do it on that basis. Now, if somebody is in the process of trying to stab you or shoot you or do something, where you qualify for those 5 words, then you have something that's there. And who evaluates that? And you're exactly right. The police will start, but it's the prosecutors that make the determination whether or not charges are going to be brought. And that's a very important concept to understand, that you had 100% better be right at the moment you make that determination, because if you're wrong, you will be charged accordingly. It is not lightly undertaken for you to use deadly force against anybody, ever. So it has to be done very, very carefully, both for law enforcement and anybody who's going to apply stand your ground. Qualified immunity is a different animal. Qualified immunity applies to the police officers in the course of their actions. And by the definition, the Supreme Court reaffirmed it in those 2 cases that you mentioned, Eddie. And you're exactly right. Each one had different variations of factors, but both of them were found by the Supreme Court to be within the definition of qualified immunity. And it creates some interesting things, because it's both criminal and civil in which they would have that protection individually. It doesn't mean you can't sue. And a good example of that is they've charged this week a Minneapolis police officer on a high-speed pursuit in which, going through an intersection, he killed a civilian, person who was not connected to it. But he had his lights and siren on and allegedly was consistent with their policy of high-speed chase. But a person died, a civilian died on that high-speed pursuit. And they charged the police officer with manslaughter criminally. And I have a very hard time, based on what I've read of the facts, to see how that's going to work. But
yeah,
they may
Brian,
know
what if he was going on a high-speed chase because the guy ran a red light? I mean, it doesn't justify a high-speed chase. We don't know all the facts. I mean,
you're absolutely right.
I mean,
that's exactly right. And the facts are whether or not he believed it was just a red light, or if he believed he was told, erroneously or otherwise, that somebody had been struck and killed by this person's car instead of just running a red light. Now, if he was just chasing someone for running a red light, then he would be in violation of the policy. Therefore, he might be out of the protections of qualified immunity. It doesn't give you a free pass. What it gives you is that when you're in the course and scope and operating consistent with a policy, and again, these departments all have policies under which you operate. The sheriff's office here has one when you're engaging in a high-speed pursuit. It not only has to be consistent with the policy, but approved by a supervisor, meaning that when you're doing this and you contact them, they have to know and they have to actually intervene and approve of what's being done. And a lot of times involving these high-speed chases, short of a very, very, very serious crime, they will not authorize you to continue the chase. Yeah. It's too dangerous.
Well, let's go back to the stand your ground on the subway then.
Sure. Absolutely.
So that's a civilian. So even if I'm not the one being threatened with imminent bodily harm,
it's not threatened. It's the person actually being attacked.
I know that. I know, but the person being
in this case was a rape
but
case.
if I'm a passenger, I'm not being attacked. The person who's being attacked is the victim. I can intercede in that situation.
Under Florida law, I would take the position you could.
Okay.
Florida law defines stand your ground as the protection under those circumstances. And if you were doing it on behalf of that woman, I don't think anybody in Florida would. Now, I don't know
but here's my
whether
question.
or not Pennsylvania has a stand your ground law similar to Florida's.
Well, let's take
flexibility in it.
Let's take Florida.
Let's
take Florida.
I don't
Guys,
think it's a justified action. It's the justification.
But here's my point.
Yeah.
The guy's beating her up. He's not. He's just beating her up. Okay, it's an assault. Typically, doesn't give anybody the death penalty, or maybe they're in jail for 5-10 years because he's beating up a woman. You intervene and you beat the guy to death, okay? Or you do something, you throw him. I mean, he ends up dying. I mean, are you going to be prosecuted for that?
Well, you're talking about two different things. Beating somebody up can go anywhere from a slap to them going ahead and choking somebody to death. But we'll change that.
Right.
Coming back to the use of deadly force. Your hands, unless you're somebody that has special training, like Mike Tyson, as a professional boxer, or somebody who's a master of Taekwondo, your hands, as a general rule, are not deadly weapons. But if you use a deadly weapon on somebody in the course of that, again, you come back to what it was they were doing at that moment in time, whether or not that was a reasonable response in protection of that person's life and your life from that person's actions. And the way you phrased it, I would say it's not. But if you change one of those factors, you can change both what can be done and what the outcome may be. And remember this, it's both the police review of it, what witnesses say, and later on the review by the state attorney's office here in Florida. Because they may review it from a prosecutorial standpoint and say, look, what you did in our mind was not justified. And if there was some connection between, the people that were involved, it creates even more complications, meaning it's a boyfriend-girlfriend dispute.
Yeah. Yes, I'm saying.
And
it's all on the
third party
facts.
to it.
I mean, if the guy, if your action makes him stop,
right,
then you should stop.
Right.
It's not like you
That's
can
right.
continue.
Yeah, but you could pull him away and throw him to the ground. His head hits the ground and kills him.
Well, that's different.
He's dead. You killed this guy.
That's like a natural progression of you trying to get him to
moving
stop.
You're moving away from the key factor, which is deadly force. A lot of people have concealed firearm permits, and once you use a gun, there's no taking that back. That was demonstrated on Thursday with that accidental killing in New Mexico with Alec Baldwin. In regard to when a gun is fired, there's no change in that.
Yeah, I know.
So the issue is whether or not
case.
at that moment in time you're justified to use deadly force in defense of yourself or somebody else.
Okay,
that's the moment.
Okay, in my mind, in the subway, he was trying to rape her. I pull out a gun and I kill him.
Say that again. I didn't understand.
On the subway case, let's say one of the people who are witnessing the alleged rape said this guy's raping this woman.
She was raped.
Okay, she was raped. Okay, I don't know. I didn't hear the story. I don't know.
I read the story that she was. So assume that's true.
Okay, so
if at that moment in time they used deadly force, absolutely would be justified.
So the passenger, like a passenger watching that, if he had a gun, he could have pulled out a gun and shot him in the head.
Yes,
okay?
That's exactly right.
And not be prosecuted.
That's right, because that's in defense of somebody that you can't, short of killing her, you couldn't have committed a more serious crime on another human being than to do that.
And her life may have been risked.
Absolutely, it was. Remember the standard. Imminent death for a police officer, a reasonable belief of death or great bodily harm. That absolutely is great bodily harm, and absolutely would justify the use of deadly force to get that person to cease that crime. If he was stabbing her, and that would also be an example of it. Absolutely. In my mind, based on the standard we have in the state of Florida, no prosecutor should prosecute it, and no jury should ever convict of it when you're doing the defense of a woman in that situation. In my mind, it's just absolutely clear. What they did was film it. And frankly, I'm at an absolute loss for anybody that would not have intervened and try to help in that situation. But that's, in fact, what they were talking about nationally, that no help was given to her of any form.
I mean, was there anybody there that was capable of giving help?
I don't know the answer to that.
If you're a 15-year-old girl sitting there,
no.
I
know
they're adults. I don't know what kind of people are around. I mean, they just assumed these people were able to. I mean, maybe somebody. I don't know. I mean,
I don't know what they were either. But I know from the perspective of if you were able to intervene and you did not, then that's something that people who were able to and did not should be ashamed of. I'll just say that. But that's my viewpoint on it. Yeah. But coming back to the question, I think there's a lot of ambiguity that was presented in the discussion, and I think they need to understand there are clear standards. There are things that clearly define what's there, and that standard is what they rely upon for making a determination of whether or not the force you used at that moment in time, and we're talking about deadly force, okay, was
getting back to the qualified immunity for law enforcement.
Sure.
There's a movement, this George Floyd Act, which has really been kind of getting bogged down. They're trying to get rid of qualified immunity for police officers. And
they are.
And law enforcement. Law enforcement is up in arms because they're saying you're making us we got to make split-second decisions, and we're in the heat of the moment. We have to act, and if you take away this qualified immunity, we're going to be getting sued every time we do something.
Well,
that's what they're saying.
I understand. It's a viewpoint, and again, first of all, you have to come to consensus if you're going to remove that. What rights do a police officer has in a situation in which he has to make sometimes, as you put it, split-second decisions about the use of deadly force or otherwise. And sometimes that's a very difficult thing to do in the protection of somebody. Recently, they showed the video of a woman who was going to stab another woman out there in the street, and he came upon it just before she was going to be stabbed, and he used deadly force, and he killed the one with the knife. And there was a lot of debate about whether or not he should have done that. But what if he had missed and instead hit the woman he was trying to protect? That's a question. And then you've got two sides of it. The criminal side, should they be charged criminally? Then the civil side, should they be open to damages for their situation, for whatever act they've committed?
The big argument, the big argument on suing police officers right now is that it's the inconsistency of the cases.
True. But that has to do with prosecutorial discretion.
Well, no, not really. I'm talking about civil rights violations, money damages. Like I gave
different issue. Then you're suing under 1983. That has to do with policy, practice, custom, or procedure, and a violation of what the department didn't do. In other words, like George Floyd, they had a number of officers who stood around and watched it instead of saying, "Get your knee off his neck," which was that was something that they're being charged with criminally, in addition to the officer who actually did it, who's been convicted.
Well, I'm just giving you two examples. Let me give you two cases here, Brian, because we talked about them last week, and this is what I'm talking about. One was a First Amendment case against a police officer where the court allowed this case to proceed. It was a situation where a person
Eddie, which court is that? Because if it's the Federal Court of Appeals in California, the 9th, that's a different thing than the 11th down here in Florida and Georgia.
Well, the 11th one dismissed the lawsuit. You're right.
They're
more conservative. Now the other one, it was in Missouri, where the reporters were the news reporters were covering a police shooting, and they were tear gassed while preparing for a live broadcast. So that news reporter sued the police for tear gassing them. Okay, and the court allowed that case to go forward. Now in the 11th Circuit, where we are, there is a case recently where the officer seized the cell phone of a bystander who was recording a police interaction. So the police was doing something to somebody. This guy records it on his telephone. The police officer grabs the telephone. And the court dismissed that First Amendment case against the police officer and said he had qualified immunity. I don't see any different between the two cases.
That's inconsistent.
Well, then
that's the 11th Circuit.
Well, that's why there's different, and you have, as you know, when you have different Court of Appeals come out to contrary decisions on similar types of matters, that's why we have a Supreme Court. And then they will look at this and make a determination. But the Supreme Court this last week on two qualified immunity cases determined both of them were within the qualified immunity exception for the officer's actions and gave specific factual examples. The problem becomes with these cases, no two are ever exactly alike. They're all like fingerprints. The similarities, but they're never, ever exactly alike for that moment in time for what they did or didn't do and why they did or didn't do it. And each one has a variation that the courts have to look at. And this particular Supreme Court at this particular moment in time is more conservative in nature, meaning it's more pro-law enforcement than it would have been, say, 15 years ago. But coming back to what you did say, and that's exactly right, the qualified immunity issue is being dealt with right now, and there was a huge debate in the Senate. And Cory Booker and I think Senator Scott from South Carolina were trying to work together to develop something that could be agreed to by everybody. And those discussions broke down because of the nature of what would be involved. And if you remove qualified immunity just from a purely civilian standpoint, what you're doing is telling the law enforcement officers that if they interact in a certain way, they're subject not only to civil litigation, but criminal. And that creates some real hesitation in regard to when you might want them to be more aggressive towards the enforcement of the law. I'm not saying always, but I am saying that in regard to certain things, if you break the law intentionally, you deserve what you get. But if there's an unintentional situation in which they're acting in good faith, that's what qualified immunity is meant to deal with.
Yeah, but let me tell you,
you can always change that.
But Brian, the George Floyd Justice and Policing Act gets rid of qualified immunity.
And that's a mistake, in my opinion.
It was introduced in 2020, and right now it passed the House of Representatives last year.
Right.
And again, this year, I guess it got revoted on, and negotiations. There are now negotiations in the Senate. So
which have broken down. They have not worked that out.
They haven't worked it out, but if it passes, there is no more qualified immunity. In addition to
let's define it for the listeners. Qualified immunity. What do you mean by that?
Qualified immunity is a court established in regard to an officer acting in his official course and duties, scope and duties. in good faith at that moment in time, depending upon what he does. And it can be anything from, as you say, a high-speed chase to the use of force at a particular moment in time, or an arrest, or other factors in which
if the agency has a procedure in place, in this situation, you can use this hold to apprehend a potential criminal, okay? And if that kills somebody, then no, you can't sue me because that's a process, that's a procedure, that's a planning decision, so to speak.
That's not. I'm talking about something different. I'm talking about something different. I'm talking about civil suits, Chuck. This is a civil matter. Suing for money damages.
Right. Well, that's what I mean. So you're immune from a civil suit because it's a part of the
individually.
Individually,
you are.
Yeah, you can't sue
but coming back to it, it's also designed to protect you from criminal prosecution, meaning that if you go ahead and use an amount of force that results in something that was there, somebody was injured in the course of an arrest, somebody was inadvertently injured because of what they were trying to do, like in this situation, a high-speed chase, somebody was killed. The question is charging them criminally, and the qualified immunity is one of the things that keeps that from happening. Gotcha. Number two, and coming back to the civil side, it protects them individually. It doesn't mean the department. Now, if the department was lax in their policies on high-speed pursuits, then they're subject to a 1983 claim or other sanctions, which is a separate issue, the department versus the individual. Because the officers don't create policy. It's created by department heads.
Brian, I get all that. We're talking about two different things here. I'm talking about these individual lawsuits against the police officers. You know,
right.
Sued.
And
I want money from you. You grabbed my cell phone. No. I was recording an incident. It's my constitutional right, my First Amendment right to record what you're doing to this guy, and you grabbed my cell phone. I want to sue you for that. That's a violation. That's
Hold on.
They threw it out based on qualified immunity.
That one.
At that moment in time, he was asking them to step back from a confrontation in which they're trying to make an arrest.
No, that's not true.
No. But I mean, I'm giving you an example of why it may be appropriate or it was inciting a crowd. If it incited people around them and caused them to feel they're in danger or somebody else is in danger. I'm just saying you could change the factor to that. Right. You could change the outcome. I don't know why he took the phone. But if they were simply there in a typical situation, what was it that they were filming that this person was asked not to do it and why they confiscated the phone?
I know it's fact specific, but I think we're talking about several different things here. You're talking about we're talking about, to me, my thing about qualified immunity, what I want to get in today is individual officers being sued for money damages. Money.
Right.
For violating someone's well, you can't. I mean you can. I mean there's a standard.
The state law is equally clear. Under 768-28, it protects the officers in their individual capacity. You know that from when we have false arrests or battery or excessive force
cases. But this George Floyd Act law, which has passed the House and the Senate, gets rid of qualified immunity, which opens up police officers to getting individually sued for money when they violate someone's constitutional rights. They grab my cell phone.
Eddie, when it's alleged they violated somebody's constitutional rights.
Yeah.
Right. But then that's a court determination after a jury. But coming back to it, it also eliminates them. Hold on. It also eliminates them from protection in the criminal realm as well.
Yeah.
That they could be prosecuted criminally for many things they could have not have been before. Now, some would say that's right and some would say it's wrong, but what it's going to definitely do is discourage people from going into law enforcement because of the situation they're in. Classic example is that woman who thought she was grabbing a taser. She grabbed a gun and she killed the suspect.
Brian, we're out of time, man.
Hey,
we'll continue this discussion.
I told you I had to get ready for it.
I'll see you.
Oh, you guys are killing me. You're killing me today.
Brian, I love you. It's always a treat to have you on the show, brother.
I'll see you at work Monday, Brian.
All right. You guys take care. Have a good afternoon. Bye-bye.
Well, that show got derailed just a little bit by the conversation, but we learned an awful lot, and it's a conversation that needs to be continued at a future date. Chuck, Eddie, as always, appreciate the opportunity to spend some time with you. To our listeners today, I hope you guys have enjoyed that insight. This is what happens when you put a bunch of lawyers together in a room. And for those of you who had a chance to call in, appreciate those calls. For those of you that we didn't get back to, we will be following up off air. So thank you so much for participation. And we look forward to talking to you again on Legal Live with Chuck and Eddie Farah here on 104.5 WOKV, Jacksonville's News and Talk.